Hi, this is Janine Percival Wright, the Director of Legal Affairs for Intellectual Property and Litigation with True Religion Brand Jeans in beautiful Los Angeles, California. You're listening to IP Fridays. Thanks for the great podcast, guys.
Hello and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 19. Ken and I want to wish you a successful and healthy year 2015. We have a special treat for you today. A judge of the Federal Supreme Court in Germany, Klaus Grabinski, is making the rules for the Unified Patent Court and will give us a status update. I will tell you about the USPTO. They have released a Patent Eligibility Guidance. And Ken will tell you about fee reductions at the USPTO. But before we jump into all this, I want to announce the winners of the Christmas mugs that I promised. One Christmas mug goes to Reg in Los Angeles. She's writing, "Thanks for a great podcast. It's a great addition to my weekly lineup. What's great about it is that it's international in nature and not purely focused on the USPTO." Another Christmas mug goes to Ed. He's writing, "Thank you very much for putting these podcasts together. I have enjoyed listening to all of them as they are very informative." He wants to know more about the interim guidance on subject matter eligibility by the USPTO, which I'm talking about today. And he also wants to know more about patent right enforcement in China, which we will talk about in the future. And then one mark goes to Ruth in London. She is our most dedicated and loyal listener. Ruth, you are listening to this and you know who I mean. And I also want to already tease an event that we are hosting. Both Ken and I will be present at the INTA meeting in San Diego in May, and we will be hosting a meetup. So if you want to meet us in person in San Diego, you will get a link in the next episode where you can register for the meetup. It will likely be on Tuesday evening. We want to meet you in person, and we will also invite the guests that have been on the show so far. So, Ken, you wanted to tell us more about the fee reductions at the USPTO.
Rolf, you will likely pay more for some items in your daily life at the grocery store, convenience store, or even when you take your next vacation. However, in 2015, the United States Patent and Trademark Office is rolling back prices for certain filing fees as long as certain conditions are met. Effective January 17th, 2015, there will be a new type of application that can be filed at the USPTO, which carries a new pricing structure. Known as T's reduced fee, practitioners and trademark applicants should consider this option to take advantage of the $50 fee reduction per class. This lowers the filing fee for one class of goods or services from $325 to $275. To obtain this savings, the application must be filed electronically via the Trademark Electronic Application System, or TEAS application form, located at www.uspto.gov, and the applicant must authorize that all communications will be via email, and that all responses and other documents required during prosecution of the application will be filed electronically. For those applicants opting for the TEAS Plus application, where the applicant chooses preset descriptions of identifications of goods and services, the fee reductions continue, such that the filing fee is reduced from $275 to $225 per class. The identifications come from the USPTO's Acceptable Identification of Goods and Services Manual, which is available at www.uspto.gov. For trademark renewals, the savings continues when a T's renewal application is filed. The filing fee for renewals will be reduced from $400 to $300 per class. That is a savings of $100 per class. The fee reductions are being put into place this year because the USPTO has increased their efficiency levels and have developed what they call an operating reserve in light of these department efficiencies. The USPTO hopes that these fee reductions will encourage additional trademark and service mark filings in 2015 and beyond. There is a helpful chart summarizing the new filing fees at http://www.uspto.gov/trademarks/tees/reduce_fees_info.jsp. A link to this webpage is located in the show notes.
So if you want to know more about this, go to ipfridays.com/trademark fee reductions, all one word, ipfridays.com/trademark fee reductions. So here it comes, our interview with Klaus Grabinski, who is judge at the German Federal Supreme Court and is making the rules for the Unified Patent Court. I'm very excited to be joined by Dr. Klaus Grabinski today. He is appointed as a judge in the Federal Supreme Court at the Bundesgerichtshof in 2009, and he is currently member of the 10th Civil Division, 10. Zivilsenat. Before that, he was presiding judge at the District Court in Düsseldorf, where we actually met. I had the chance and fortune to be one of his trainees for 2 months. So welcome to the show.
Thank you very much. It is my great pleasure to contribute to this program. And it's also, of course, a pleasure to speak to you again after so long time.
So maybe you can tell our listeners a little bit more about yourself.
Well, as you already mentioned, I'm judge at the Federal Court of Justice, which is the Supreme Court of Germany with regard to civil and criminal law matters, where I'm a bit more than half of my time dealing with patent cases, revocation cases, as well as infringement cases. And I'm now for about 3-4 years, member of the so-called drafting committee that is dealing with the drafting of the rules of procedure of the future unitary patent court.
All right. So since you're currently working on the rules of the Unified Patent Court, maybe you can give our listeners who may be copyright or trademark practitioners a brief summary of what the European patent with unitary effect actually is and what the Unified Patent Court is, and maybe you can also summarize the benefits that people are expecting from these new entities.
Please let me start with a short look on the current situation. As you know, we do have in Europe a national patent and we have the European patent. European patent essentially means you have one stop for the granting of the patent, meaning you can file an application to the European Patent Office, and when you are successful, a patent has been granted, what you essentially get is a bundle of patents, meaning you get protection like a national patent in the contracting states you designated. And the problem here is that you have to go, when you want to enforce the patent, you have to go to the courts of each of the contracting states in which you want to enforce the patent. Which resulted in the past in a number of parallel infringement litigations, namely in Germany, in the UK, in the Netherlands, in France, etc. And so some people thought that this is costing a lot of money and a lot of time, and sometimes also results in different decisions. And so there was kind of a demand for also a one-stop system, not only on the prosecution side, but also on the infringement, on the enforcement side. And this is essentially the idea of having one court for a number of European states with regards to infringement litigation.
Right. And maybe just to briefly bring our listeners up to date with the European patent with unitary effect. Currently, the situation is the way that you would have to validate, after granting of the patent, you would have to validate in each national state, member state, and in the future it might be possible to actually validate the patent in most of the EU countries as one entity. At the moment, just Italy and Spain are not playing with us, but the rest of the member states joined this new effort, basically.
Yes, you're right. We will essentially have two kinds of European patents. The so-called classic bundle patent will still exist, and this bundle patent during a transitional period can be enforced before the national courts or alternatively before the new unified patent court. Unless the patent owner opted out. There will be an opportunity for opting out the patent, and the consequence of this opt-out would be that the patent will still stay exclusively with the national courts, as the situation is right now. But the new court will also deal not only with the bundle patent, the classic European patent, but also with this new patent you mentioned, the so-called European patent, which will give unitary protection to all member states. And with regard to this new patent, the unified patent court, the new court, will be the only court also during the transitional period. With regard to infringement litigation, when I'm speaking of infringement litigation, this also includes revocation actions or counterclaim for revocation.
Right. And in the beginning of November in Trier, there was an oral hearing on the 17th, so quite a few iterations, version of the rules, and hopefully the final draft of the rules for the UPC, the Unified Patent Court. So can you give our listeners a brief summary of this particular meeting?
Yes. As you rightly mentioned, there were already a number of drafts before, and the draft of the rules of procedure, which was the basis for the Trier public hearing, was a so-called 17th draft. You may raise the question, why do they need so many drafts? But maybe as a kind of explanation in this regard, this is I think the first example where you have rules of procedure that are not only inspired by either civil law or common law, but that are a kind of merger between the civil and the common law procedural law. And so this to get to results also in view of a very particular litigation, which is the patent litigation, it took quite an effort, and this is the reason why we are now talking about the 17th draft. As you rightly mentioned, the 17th draft has been the basis for this oral hearing, where all stockholders could attend and comment and comment on this draft. The public hearing essentially dealt with four main issues, controversial issues to some extent. The first one was the so-called opt-out. I already mentioned this. You can opt out with the European patent from the new court if you do want to stay with the national courts, and there are a few technical issues that were discussed in Trier. The second issue was the language regime before the new court, the Unified Patent Court. in particular before this local and regional divisions. The third point was injunctive relief. As you probably know, injunctive relief will be a matter of discretion under the agreement on the Unified Patent Court, which is different from the situation we have at least in Germany right now, where the court has no discretion. Once infringement has been established, the court has to issue an injunctive order, unless there are some reasons with regard to good faith, but which is really very, very, very exceptional. But with the new court, it is discretion, but still, even though it is discretion, which was also mentioned in Trier, and probably there are some indications that the new court will follow the practice of the English courts, which, even though they have discretion in deciding on injunctive relief, they only they most of the time they issue an injunctive order once infringement has been established, and this was largely discussed in Trier, this issue. And the fourth point is about procedural appeal, which was also controversially discussed issue, meaning whether all procedural orders and decisions of the court can be appealed, and the current 17th draft provides in this regard that procedural decisions can be appealed when appeal has been a leave for appeal has been granted, and if no leave for appeal has been granted by the court of first instance, then the party concerned may issue a request for a discretionary review, on which the so-called standing judge of the Court of Appeal will decide, and only if he supports the discretionary review, then this decision, then the way is open for procedural appeal. And if the standing judge says no, he is not allowing discretionary review, then this issue will not go to the Court of Appeal. So these four issues were largely discussed in Trier, and in addition to this, also a number of more technical issues.
Right, and I heard there was some discussion about the language that can be used by the regional courts.
Yes, the principle with regard to language of proceeding before the local or regional court is that the language is the official language of the member state, participating member state that is hosting the local or the regional division. However, it is also provided for in the agreement that in addition or instead of this language, it can be one of the three official languages of the EPO, meaning German, English, and French. And so there is now a lot of discussion going on whether local divisions should, at least in addition to the official language, also add one of the EPO languages. And of course, most of the time, it is discussed whether English should be additional language to the, let's say, local language. What was discussed in Trier is whether this second language, the EPO language, can also be restricted only to a particular part of the proceeding, meaning that, for example, English as a second language, so to say, can be only used for as an additional language, can only be used, for example, for the written pleadings or only for the oral hearings, which could result in a situation in which the plaintiff could use English before, for example, local division in Germany, but the defendant would use German, and the court would also use German as a language. And the discussion in Trier was essentially about whether this is a good way to deal with proceedings. And what was discussed, for example, is a situation before the EPO Board of Appeals, where some of the people attending the public hearing were mentioning that also a number of, or not only one language is used, but also a second or third of the EPO official languages.
That's interesting to see that some other languages besides English might play an important role in the system. So what, in your opinion, would be the major obstacles that still need to be overcome for the system to really work?
Well, I think there you can essentially differentiate between the legal obstacles that still have to be overcome and the so-called practical or material obstacles that have to be overcome. Let's first turn to the legal points. It is the agreement provides that the whole system is ready for start when 13 of the participating member states have ratified the agreement exactly, and including the three big ones where the most of the application were filed in the past. And currently we are at a stage where 5 of the participating member states have ratified the agreement, including France as one of the big 3. So we are waiting for the rest so that this threshold is met. In addition, of course, a lot of other pieces or legislation has to be prepared concerning questions of, for example, legal aid or the provisions dealing with the qualification of patent attorneys to be admitted to the court to present cases on their own. So a lot of other issues have also still to be prepared in this regard, and of course also the rules of procedure that are almost finished but not finished yet.
So you just mentioned some legal obstacles. Are there any like the material obstacles also
I
to be overcome?
I think one of the most challenging ones is the setting up of the IT infrastructure for the new court, because this is technically, I think, challenging, and it also needs communication between the IT specialists but also from the legal point of view. And this has to be set up in a number of contracting member states, which we even do not know at the moment where the local or the regional divisions will be. So there, I think there's still a lot of work to be done, and I think it has to be really operational when the system is going to start. We cannot afford to have a non-operational IT system and kicking off the whole thing. So this, I think, is one very essential point. Another one is, of course, the training of the judges, and also the setting up of the building and the personnel below the judges level, and all these kind of things.
Right. So this court will probably handle, or people expect the court to handle quite a lot patent litigation. So where do you see the German patent litigation going, and will there be the bifurcation system in the future, or do you see that going away?
Currently, I do not expect major changes in this regard. The main problem at the moment with regard to bifurcation is probably that it takes too long to get a decision from the German Federal Patent Court in parallel to infringement litigation before one of the district courts. This probably is a problem that has to be addressed. If once infringement litigation has been started, you will get in a shorter time also decision, at least a first instance decision in the parallel revocation proceedings. Then I think by and large the bifurcation system as we have it right now in Germany is a well-functioning system and could continue for also in the future.
So do you see the number of patent litigation cases going down in the near future, let's say for Düsseldorf, Hamburg, Munich or Mannheim? And do you see the Unified Patent Court replacing basically the patent litigation courts that are currently mainly used? Or do you see that as an additional, court where people will go to court? Do you see a future for the national courts, basically?
I think a number of stakeholders will lean back for some time and see how things are evolving once the new system has started. And when the new system is doing well, then they might be interested also to litigate before the new system. If the new system is not doing well, then at least for the transitional period, of course, the national courts will still be attractive. There you know what you get, essentially. And so I think for the time being, at least for the first 7 years, the transitional period will last 7 years. I think we will see both systems, the new system evolving step by step, and but of course still you have the national courts that have in the past proven to be efficient, at least in some contracting member states. And I think for the time being, you will see both systems, and only if the new system is really going to be a success story, then of course you will see, at least to some extent, a shift from the national courts to the new system. Maybe also depending a bit on the kind of case, whether it's more a case that is more cross-border with cross-border aspects, or whether it is only a litigation or infringement that concerns only one country. Then, of course, it may still make sense to go national.
For example, our firm mostly represents medium-sized clients, not the really huge corporations, and the medium-sized clients, or even the larger corporations, they see that the German system is quite cost efficient compared to the expected costs of the UPC, and it's probably quicker. And anyway, currently, like 2/3 of all patent litigation cases are handled by German courts, and in Europe. So my personal expectation is that the German court system will still have a very good future in patent litigation.
Yes, basically I would support this view. I do not fear that German patent judges will get unemployed in the near future.
Sure. So some applicants fear that the judges with nearly no patent experience so far might cancel their EU-wide patents. Are these concerns justified?
I think the future will tell. And the statute, like the agreement, essentially provide two requirements with regards to the appointment or selection and appointment of judges. And the one point is that the judges shall be have them be experienced in patent matters, and the second point is a balanced composition of the court, geographically balanced. I think both aspects are to some extent justified because, of course, we need experienced judges for the new system because otherwise you could not deal with this with patent matters. On the other hand, of course, this is going to be a court for not only the 2, 3, 4, 5 experienced with regard to patent litigation experienced member states, but for a number of for more member states, and they also have to be represented to some extent. My personal formula would be, and I'm thinking a bit of my time as a presiding judge in Düsseldorf, where we also had young colleagues that had no experience as part of the judges panel. And in Düsseldorf, where panel 3 judges decides the case, as long as there is only one less experienced judge, I think the system is still working quite well, as long as the other 2 judges are experienced. Transferring this to the new system, I would say where we also have a panel of 3 judges, at least 3 legally qualified judges, at least for the with regard to the local and regional divisions. As long as you have 2 experienced judges on the panel, I think it is possible to have a third one who still has to gain his experiences. But if it would be the other way around, only 1 experienced judge and 2 not experienced judges, then I think I would be a bit worried about the future of the system.
So thank you very much for your valuable time. This has been extremely helpful to hear from the source, basically, of the rules. So thank you very much to be on the show.
It has been my pleasure. Thank you very much.
So I really hope that you got as much out of this as I did. Finally, I promised you to tell you more about the USPTO Eligibility Guidance for patents. Following the Ellis decision in June, the USPTO issued this guidance. It is a 56-page document, so quite lengthy, and replaces the very similar KSR guidelines. So I won't go through all these pages. I will leave this to you. But in general, the guidance goes through the various decisions. In Ellis, the Supreme Court made clear that patents can no longer be granted for natural phenomena and for just abstract ideas. And in this guidance, the USPTO gives examples for natural phenomena, such as isolated DNA or a correlation that is a consequence of how a certain compound is metabolized by the body, or electromagnetism to transmit signals, or a chemical principle underlying the union between fatty elements and water. And as examples for an abstract idea, the USPTO is listing mitigating settlement risks or hedging, creating a contractual relationship, using advertising as an exchange or currency, or similar abstract ideas. So in Ellis, the Supreme Court developed the idea to grant patents based on such phenomena or abstract ideas if there is significantly more to the claim. And in the guidance, the USPTO defines the significantly more as an improvement to another technology or technical field, improvements to a functioning of the computer itself, applying the judicial exception with or by use of a particular machine, effecting a transformation or reduction of a particular article to a different state or thing, adding a specific limitation other than what is well understood, routine and conventional in the field, or adding unconventional steps that confine the claim to a particular useful application, citing Mayo, or other meaningful limitations beyond generally linking the use of the judicial exception to a particular technological environment, citing Ellis. Fellow blogger Gene Quinn has an exceptionally well-written summary of the guidance, and I am giving you the link here so you can find his summary by going to ipfridays.com/patent eligibility guidance, one word, ipfridays.com/patent eligibility guidance. So with this, I hope you enjoyed the show and hope you tune in next time.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.